Picture this. Over 2,000 years ago, Aristotle actually sat down and analyzed 158 different Greek constitutions. 158! And he wasn't just doing this for fun, right? He was literally trying to figure out the ultimate puzzle. Why do some societies absolutely thrive while others completely collapse? Fast forward to the Roman Republic, and they had a temporary dictator role built right into their legal system for massive national emergencies. Why? Because constitutions aren't just dry, dusty legal text sitting on a library shelf somewhere. They're living, breathing blueprints built for survival. So welcome to today's Explainer. We're diving headfirst into the fascinating world of comparative constitutional law. Now, some scholars like to debate whether this field is a hard science or just a method of studying law, but honestly, the reality is that comparing how different nations structure their rules is absolutely crucial. It influences diplomatic bargaining, it shapes judicial activism, and it proves that the law is basically a living tree. Today, we're decoding the architecture of global power. And that brings us to the ultimate historical question. How do you actually stop a government from turning into a tyranny? Seriously, think about it. If you give a leader enough power to protect you, you've simultaneously given them enough power to oppress you. It's a huge paradox. Different countries have engineered some wildly different, honestly super creative mechanisms to solve this exact problem. And here's the real secret. If you want to understand how your own rights are protected, you can't just look inward. You have to look at how the rest of the world does it. We have to compare. So here's our roadmap for today's Explainer. We're going to start with power divided, looking at the foundational theories of keeping government in check. Then we'll explore the two legal worlds that act as the operating systems for these nations. After that, we'll dive into the mechanics of choosing your government and global legislators before zooming in on executive powers. Finally, we'll hit the climax of our journey, the ultimate check, looking at what happens when the very core of a constitution is literally under attack. All right, Section 1, Power Divided. Foundational theories. So before a nation can pass even a single law, it really has to decide how to divide its power. This concept of splitting power to prevent abuse goes all the way back to ancient philosophy, but it was really sharpened up during the Enlightenment. John Locke, for instance, recognized a really practical reality. You need a continuous executive power to run things day to day, but a discontinuous legislative power that only meets sometimes to actually make the rules. Listen to how bluntly the founding fathers of the United States viewed this threat. James Madison, totally echoing the French philosopher Montesquieu's famous 1748 warning, basically said this: if you put the power to make the laws, enforce the laws, and judge the laws into the exact same hands, you have literally designed a tyranny. Period. No way around it. The U.S. took this absolutely to heart, with a rigid, written constitution enforcing strict separation. But not everyone does it this way. The UK has an incredibly flexible, unwritten constitution with massive overlap. I mean, historically, their top judges even sat in their legislature. And then you have India taking this brilliant middle path, building what we call constrained parliamentarianism. They don't have absolute rigidity across the whole board, but Article 50 of their constitution specifically directs the state to separate the judiciary from the executive. Moving right along to Section 2. Two legal worlds. Step 2 in all of this is deciding what foundational legal language those separated branches are actually going to speak. Let's look at the two dominant legal operating systems in the world right now. On one side, we've got the common law system, which was born out of the Norman conquest of England way back in 1066. In places like the US, the UK, Canada, and India, the law isn't just what's written down in the statutes. It's heavily based on binding precedents, meaning past judicial decisions. The courts are basically an adversarial battleground where judges actively shape the law. On the flip side, we have the civil law system, used in countries like France and Germany, tracing its roots all the way back to Roman law. Over here, it's all about strict, comprehensive codification. Judges in this system play an inquisitorial role. They're more like investigators applying rigid codes rather than lawmakers creating binding precedent. And let me tell you, it completely changes how power is wielded from the bench. Okay, Section 3, choosing your government. Executive structures. So how do nations actually build their executive and legislative engines? Choosing the right system is honestly perhaps the most fundamental aspect. Actually, scratch that. It is the most fundamental aspect of constitutional design, because it directly impacts whether a country enjoys long-term stability or just descends into total gridlock. Think about it like this. The U.S. presidential system is built on mutual independence. The president and Congress are elected totally separately, and they serve fixed terms. But the famous political scientist Juan Linz warned that this creates a super dangerous zero-sum game. Basically, if the president and the legislature belong to different parties and both claim democratic legitimacy, you get massive gridlock or worse, total democratic collapse. Now contrast that with the parliamentary system in the UK or India. That is built on mutual dependence, where the executive is drawn directly from the legislature. Dr. B.R. Ambedkar, the chief architect of India's constitution, directly countered that US-style independence. He famously argued that while the US system offers more stability, the parliamentary system offers vital daily accountability. The government can literally be ousted at any moment by a vote of no confidence.
And here's where it gets wild. France uses a semi-presidential system. It's a hybrid with a dual real executive. So they have a popularly elected president with huge powers, plus a prime minister who is accountable to the legislature. When the voters elect a legislature controlled by a party opposing the president, it forces this crazy situation called cohabitation. It's basically the ultimate political awkward roommate scenario. The president handles foreign affairs and defense, what they call the reserve domain, while the opposing prime minister basically runs all domestic policy. It is an incredible constitutional balancing act.
Let's move to Section 4, Global Legislatures, Chambers of Power. So we know how the executive is chosen, but what about the actual rooms where the laws get made? The physical and structural layout of a legislature tells you everything you need to know about a country's priorities. It essentially boils down to this: speed versus balance. Unicameral, or single-chamber legislatures, are typically found in unitary states, like Denmark or Sweden, where power is heavily centralized. One house means you can pass laws incredibly fast, which is great in a crisis. But if you have a massive, super diverse federal country like the US, or a complex historical structure like the UK, you really need a bicameral, two-chamber system. In the US, the House represents the population, but the Senate acts as a vital check, ensuring that small states have exactly the same voting power as massive ones. It purposefully slows things down, by design, to balance interests and prevent the tyranny of the majority. Which brings us to Section 5, Executive Powers. Once the laws are passed, who is actually enforcing them day to day, and exactly how much power do they really hold? Let's take a look. Under Article 2 of the U.S. Constitution, executive power is a surprisingly solitary affair. It's vested entirely in one person, the president, who acts as commander-in-chief. Over in India, it's a dual executive. The president is largely ceremonial, while Article 74 vests the real operational power in the prime minister and the council of ministers. But then France takes it to another level entirely. Under Article 16, the French president acts as an arbitrator, sure, but they also hold extraordinary emergency powers that allow them to take virtually any measure necessary if the republic is under immediate threat. All right, Section 6, the ultimate check, system fail-safes. We have arrived at the climax of our structural journey. What actually happens when the system completely breaks down? What happens when a legislature goes rogue and tries to pass laws that violate the very spirit of the nation? This right here is the ultimate tension between constituent power, the foundational power of the people, and constituted power, the day-to-day power of the politicians. When it's time to trigger an ultimate failsafe, common law systems like the US rely on really dramatic post-facto adversarial showdowns. The courts have the power of judicial review, which was established in the legendary 1803 case Marbury v. Madison, allowing them to strike down laws after they've been passed if they violate the Constitution. Civil law France does it completely differently. Their 9-member Constitutional Council is proactive. They review acts of parliament before they even become law, stopping unconstitutional legislation in its tracks before it can ever be enforced. But what if a government doesn't just pass a bad law, but actually tries to amend the Constitution itself to secure absolute power? The U.S. handles this by making amendments incredibly rigid, under Article 5, where the president actually has no role at all. Australia requires a massive double majority referendum, but India faced a totally unique crisis. Unlike Germany, which has an explicitly written eternity clause in Article 79 to prevent another dictator like Hitler from dismantling democracy, India didn't have one. So in the epic 1973 case of Ananda Bharati case, the Indian Supreme Court invented something absolutely breathtaking: the basic structure doctrine. They essentially proved they could step in and strike down actual constitutional amendments, and later drastically expanded personal liberties in the landmark Maneka Gandhi case. It is literally the ultimate power move to save democracy from itself. As we've seen today, constitutions are subject to comparative change, replacement, and totally dynamic evolution. They're not static at all. The smartest nations don't just blindly adopt foreign laws, they adapt them. India looked at the whole world, borrowed the best parts, and adapted them to their own unique reality.
So we'll leave you with this final thought. We've seen how strict separations, dual executives, and basic structure doctrines act as these powerful immune systems for democracies. But if your fundamental rights depend entirely on the mechanics of how power is divided, is your constitution resilient enough to survive its next major crisis? If you really want to understand the true strength of your own rights, you literally have to look outside your borders. Thanks for joining us for this explainer. Keep questioning the architecture of power around you, and we'll see you next time.